Hello, my name is John Birchall. I am a non-practicing barrister. I take a special interest in civil procedure, and I'm going to talk about admissions. This is a topic which is particularly relevant for personal injury practitioners, but also relevant for all practitioners. I'm going to split the discussion into two parts to make it a bit more digestible, I hope. First, the lecture has been prompted by a recent change in the rules, which you will be familiar with, certainly if you're in personal injury work, which states in CPR 14(1)A that admissions made before an action starts are binding in the sense that they can't be withdrawn without the leave of the court unless they're not compliant. If they comply with this section, in personal injury cases and in medical negligence cases, and in cases of illness, then they can't be withdrawn. Before we talk about that in more detail, I'm going to discuss the background and some of the surrounding issues, because there's really more to this subject than may at first meet the eye. To start with, you can admit a fact, or you can admit liability, not the same thing at all. And of course you can admit liability in response to a claim form. When the claim form arrives, you can admit liability for a specified sum, or you can admit liability for a sum to be determined. Subject to the special rules for admissions which may be made in a without prejudice context, all kinds of admissions are governed by CPR 14. They're governed by the same body of law, although there are some complexities about different kinds of admissions, which I'm going to talk about. Now, if you admit a claim in response to the claim form, judgment will be entered as an administrative act, what lawyers used to call a ministerial act. That is not a judicial act. And this has certain consequences. One of the consequences is that there's no time limit for applying to set aside a judgment entered as a ministerial or an administrative act. Another consequence is you can't normally use it as a foundation for an argument of res judicata in a foreign jurisdiction. In most cases, of course, this isn't relevant. You still have an enforceable judgment in your hand if you're a claimant and an admission has been made of that kind. Admissions of fact and admissions of liability can be implicit. This is referred to in the White Book. I don't think that the body of law really has any vitality now. It's very unlikely that a claimant would succeed in entering a judgment on the basis of an implicit admission. Having said that, a claimant might well want to refer to an implicit admission as a previous contradictory statement. And so therefore, if you have badly drafted pleadings, you might want to, you might well get an implicit admission because a defendant has failed to deny an allegation. And the law relevant to that is in CPR 16, of course. And I print that out on the sheet in case you want to refresh your memory. All those asides, to come on to something more substantial now, it's very important to be precise about what you are admitting. And it's quite easy to overlook this, and a case where it was overlooked is a case of Blundell and Rimmer. You've got the reference on the sheet. And here it looks as though the letter admitting negligence but denying loss was written by a busy solicitor, and he hadn't really thought about causation. And it was rather a strange case because the claimant, according to the defendant, hadn't suffered any loss, but the defendant admitted the negligence. The claimant thought, well, this is really an admission of liability. The defendant, in spite of denying that he had to pay anything, had paid some money into court. And it's not really clear what was going on in the defendant, in the claimant's mind, but the claimant sought to enter judgment on liability and then go on to dispute quantum. And it seems as though the reason was that the claimant thought that if he got judgment on liability, then any interest on the money that had been paid in, if he got that money that had been paid in, would be due to him from the date of that judgment.